That will never be settled in from.
No, but great. Thank you. Welcome back. We are now complete as a committee and as the SDHGAT. So we are discussing the amendments to S230. We have had a request to consider including the definition of a healthcare provider in with the first amendment, which is doing the non-competes for healthcare workers. There's agreement broadly in the healthcare community and with labor. There's been no issue with labor to include this language and to get these non-competes in place so that our travelers can stay here if they want to become full-time Vermonters and full-time Vermonters. And so, Keisha, I guess Sophie, if you'd be kind enough to share with us again the definition of healthcare worker, and if you will, Keisha.
This is what we're going to talk about.
Yeah,
Get that on the website.
Yep.
So this is I think it would be the first instance of amendment. It is 3B, agreements with healthcare providers.
So Sophie Zidani for the Office of Legislative Counsel. What I put up on the screen is draft 2.1. So this is the same as the one you have, except it adds in a definition of healthcare providers. I've added that in at subsection D. So it's now at the bottom of page 2.
Right.
Again, this is the definition we've looked at, and then I just renumbered the subsequent one. So this is the new language in version 2 of that.
Okay, great. And can you just read it for those of us kids?
Yes, so I make it bigger too. It says, healthcare provider means person licensed, certified, or authorized by law to provide a professional healthcare service in the state to an individual during that individual's medical care, treatment, or confinement.
Thank you. Okay, and that's just the sort of standard definition that's used broadly. Devin, you agree?
Yes.
Right. So, how do people feel about this? We've kept this conversation alive, and David and Randy.
Page 2, line 1, please. Number 3. So it's void and unenforceable if it restricts a healthcare provider from making disparaging statements about another party to the contract. So this is prohibiting NDAs.
No, not prohibiting.
This is prohibiting non-disparagement.
That's common.
So if you have a provision in a contract that says that the person signing the contract, so the employee, is not allowed to make disparaging statements about the employer, that provision would be void. And that's to protect employees to be able to raise concerns, particularly in the medical field, about patient safety or whatever it may be. From a labor perspective, it enables them to talk about the working conditions. So it's just precluding a ban on disparaging statements, because that could have a chilling impact on.
Yes.
So this is at the time of contract. If the person is leaving.
No, this provision is not just about when leaving. This is to do with any provision in a contract or agreement that creates or establishes the terms of a partnership, employment, or any other form of professional relationship with a healthcare provider. So it's not just when you're leaving.
Well, is it when that's what I'm asking is, I would think it's only when you're entering into the contract, not when you're exiting the contract.
This is saying that if you have a non-disparagement clause in a contract or agreement with an employee, that non-disparagement clause
creates or establishes it first. So it's only when they enter into an agreement, not when they exit an agreement.
Well, there's an employment agreement at that point of termination that they both have to sign. And that's typically a non-disparagement is typically part of, it's a two-way street. It's not a one-way street. Neither party can disparage the other. They have to agree to it and they have to sign it. But very common.
So if you had a bad breakup between the employer and the employee, and as part of a settlement or whatever to resolve claims, that would be separate.
That's
right.
Separate.
You could have a non-disparagement, as you say, that goes both ways in that. This is talking about when you're establishing at the start of the relationship, you can't have a non-disparagement clause in, or you can, but it would be void if you had it in there.
I think I'm stuck on the about another party to the contract or
What line are
agreement
you on?
two. Page two.
Right.
About another party to the contract or agreement about another person specified. How many people could this be? Like, could this be a general contract and you're allowed to speak ill about your colleagues?
I'm gonna let Jessa, if you want to weigh in.
Jessup Barnard, Vermont Medical Society, my understanding is this is a fairly typical definition of a non-disparagement agreement that would be in an employment contract. And the intent is that during the course of your employment, you could raise concerns about quality of care or other issues. I think the agreement would typically, or a non-disparagement agreement typically is about the employer itself, not necessarily about other employees. It would depend how that non-disparagement clause was framed in the contract.
And this is with employees and employers that have contracts.
That even
This
have,
is not for under the table care. This is not for people who are not licensed. This is for licensed.
But
And
I'm trying to understand exactly what this says, and I haven't heard that yet. This is when you are, and this is making only a contract that you enter into, null and unenforceable.
Just that provision, it doesn't render the whole contract or agreement unenforceable. It should, that provision, if you had a non-disparagement provision in a contract or agreement, that provision itself would be unenforceable.
I don't think that's what it says. Because they're all ors. Any provision in a contract.
Right, so any provision,
establishes the truth.
the provision will be unenforceable.
Shall be
Provision, and then it lists out the different kinds of provisions that would be unenforceable. So that's one of several provisions that would be unenforceable under this proposed language.
Jessup Barnard, Vermont Medical Society, if it's helpful to explain the sort of origin of this language, it really came out of the conversation in H583 around private equity and concerns that healthcare organizations, the employees of healthcare organizations seen in other states, when a sort of for-profit entity takes over ownership and really starts to restrict clinical decision-making or other starts to require less time with patients or other concerning behaviors, that then those corporate entities, which we don't have in Vermont, just to say, but it's sort of where the origin of this language came from, was wanting to make sure if anything like that happened in the future in Vermont, that those employees would feel comfortable speaking out or not be prohibited in their contract when they started working for that employer from sharing concerns about those working conditions.
Okay, it just seems really broad because I don't know who another party to the contract or another person specified in the agreement as a third party beneficiary of the agreement.
Again, I think it's broad in order to encompass
a
a variety of contracts and provisions. And again, as Jessica just indicated, I think this originally came out through the healthcare side of things. And again, I'm not familiar with all the different types of contracts there could be, but this is just to make sure that there isn't some loophole where, right, you can't disparage us, but you also can't disparage,
Right.
the corporate overlords or whatever. I mean, however it works.
So this is saying you can't disparage anyone.
Right, well, you can't write about another party to the contract or agreement or about another person specified in the agreement. So it's not completely broad. I mean, it has to be still tied to what's in the agreement.
And just to be clear, you can't prohibit someone from disparaging. You actually can. So if you want to flip to the positive, you actually are freeing employees to make disparaging statements. In fact, is just to put it
So they
bluntly.
can make complaints.
So they can make
about
complaints about
Just employees.
employees or other. It could be a contractor. It could be any healthcare worker who has a contract.
Right, it's the parties to the contract, right? So this would be the employee signing it and the employer or whoever entities are involved with the employer.
And I can imagine a third party beneficiary, perhaps an example might be like the board of trustees of an
Or a hedge
organization.
fund.
So it's not just say it's X entity plus their board of trustees.
Yeah.
You can't make statements. So there could be a contract that's broader than just, X employer entity. You also can't, it could also say you can't make disparaging statements about these other, our board members. So
Right,
this is to say, no, you can't prohibit that, not just for our entity, but also
right.
for the board, as an example.
And I hope the committee can appreciate, I'm asking questions not just in the context of healthcare, but if this is the first non-compete we're putting in place in the state, we're going to have to measure any other non-compete we introduce in future years. We're going to have to measure them against this and say, are we letting some groups disparage someone and not letting other groups disparage someone?
We're setting standard precedent.
We're setting, this.
But is this in fact our first non-compete? I thought we had non-competes in other areas.
We do have some odd
Yes.
ones for barbers and cosmetologists.
In OPR, we've looked at, there are some non-competes.
Yeah.
Are they this thorough?
No,
they talk
these
about
are disparagement. These are just to do with barbers and cosmetologists.
So if we do non-solicitation and non-disparagement, that kind of thing. I'm not clear from what we've heard so far if it's a standard practice to include all three together.
Again, this is specifically for these healthcare agreements. So yeah,
Right,
I
but some of
take
us
your
have been here
point.
long enough
Right.
to see why did we do it for healthcare workers and now we're not doing it for this group? So
Well,
we have to think long term.
Question is this is standard that you see in
Yeah.
healthcare profession?
Right. Is
Yes,
this
Jen.
the same language in Massachusetts?
Devin, I'm going to turn to Devin.
Devin Green from the Vermont Association of Hospitals and Health Systems. I will say that this is more of a forward-looking protective measure. Hospitals do not do these things now. We do non-disparagement and, someone is leaving the organization and both parties agree to non-disparagement clauses. We do that,
Okay.
but we do not do non-competes or, the other sort of, So this is more looking forward. This came out of the private equity context and looking forward and saying, going
Right.
forward, we don't want these things to start happening,
Right, which is
even though they're not happening.
which is the bill we passed yesterday on the floor.
Right.
And
So when UVM Medical would enter into an agreement with anybody, right, they have not
They
to
don't,
date had an entrance
Right.
disparagement clause.
that's my understanding.
Okay. And what we're worried about is that larger private equity firms
yes,
will make it more standard to have a entrance disparagement
Correct.
clause. Yeah.
and Jessup, you wanted to weigh in here.
Joseph Barnard, Vermont Medical Society, I was simply going to comment that I don't know that any other state necessarily has this exact combination, but these types of provisions are all present in other states. These are not novel concepts, especially given the unique desires in healthcare to make sure we are not restricting patients' abilities to both continue with their provider. Also, they, really wanting to preserve, make sure employees can speak out about health safety issues. So none of these are novel. I would have to go back. I do, and I'm happy to share with you. I had a longer memo we shared with in the House about which states each of these sections kind of were taken from, but they are all established concepts in other states.
Was there a
Healthcare specific.
case where somebody disparaged a national private equity?
This is the big example that there were a number of experts who testified in House Healthcare about the example of Steward Healthcare in Massachusetts.
Yeah.
That was bought up by
Pilgrim or whatever.
I think that sounds right. I won't say the wrong name, but by a private equity company, and really a lot of the, extracted a lot of income and value from that healthcare institution, and then left a lot of healthcare providers and patients worse off. I think would be the summary of the situation. And so some of this and a lot of the employees felt like they could not speak out at the time.
Okay.
So it took a long time for some of this to come to light around some of the changes and policies and procedures they were putting in place in those hospitals.
So that,
So that's an example that led to other states being very interested in
well, and
addressing
it's led to a lot of the work that we did
On
with
Friday.
health and welfare on the same issue.
Great.
Do you want to still include the definition of healthcare provider?
I think we need a definition of healthcare provider that we're referencing
And they,
in the note.
everyone is happy with it from what we're hearing. Okay, so I think if we include the healthcare provider definition, great. I am, David and Randy indicated he was, okay with the first instance of amendment, this healthcare provider non-compete. David, where are you on it?
Yeah, hopeful.
Okay, great. So, and then the second instance of amendment, Sorry.
Just quickly on that. So would you be the reporter on?
Yes.
instances?
he's the reporter for the bill.
Okay, then I will send a cleaned up version, but your name will be first.
Sure. Very well covered so far. We're gonna need to.
Right.
There's two other pieces that we need to confirm, but yeah, you can look at primary.
Yeah, because they're separate amendments. So
Well, if we could make it the first instance and with two instances of them. And then the second piece is the facilitated conversation between the Department of Corrections and the Vermont State Employees Association. I think everyone is on board with moving this conversation forward. The Secretary of Administration stopped by to say they were grateful also to Wanda for taking this on. So I think we're all grateful for moving this discussion forward.
I'd like to look. I think develop a proposal. I was wondering if the language could just say, like, this moves forward without us.
Yes, it is rules. Well, Sophie can speak to this because it doesn't necessarily need us. You're right.
right, so
But
currently,
it needs us to move the conversation.
there's a state facilities rule that was passed in 1999 by the Agency of Administration, went into effect in 2000. And it deals with facilities, state facilities, what's permissible solicitation, what is not. But it has a specific carve out for the Department of Corrections and says the Commissioner of Corrections can sort of pick and choose what they want to do. And my understanding is, and the testimony I believe you had it in front of this committee from the VSEA, is that the Department of Corrections has not taken up that offer to determine what rules apply to their facilities and specifically to their parking lot. So this is intended to move that conversation forward. So the Commissioner of Corrections or designee would meet with representatives of the VSEA to develop a proposal for consideration by the Secretary of Administration.
Can we change who approves the proposal? Can it be LPAR? Or the joint justice oversight?
I mean, this,
I don't think we entered in this. Who approved those rules? The rule that Wanda,
the Secretary of Administration.
yeah, it's all within the administration.
And it's been delegated by statute to,
And she said, we'll deal with this once they have.
Okay, where was it delegated by statute?
it's in statute, and I can pull them out.
Couldn't we undelegate it? Because that's the problem that they're having. Could
Okay.
we,
That would be a significant
I don't think we're ready to do that at this point, but this was never in the legislature. This was always by rule. And this, I think having the administration solve this problem and work together to solve this problem.
well,
If it is not solved, we'll obviously hear about it in January, but I think that,
I
when
would say
Sarah
it says
Clark
for
and-
consideration by the Secretary of Administration. Can it say for
Good line.
approval, line 10? Can it say for approval? Can it say, they need to report the outcome to joint justice oversight by December 1st of 2026? This feels like a real weak provision.
that they won't actually act on.
Like what
That they would just
requires
consider.
them to act on this at all? Nothing. That's in language that I.
For adoption. How about for adoption? How about that?
I would, so
So if we say
So
instead of.
is the for adoption linked to January 1st?
Yes, as I read it,
I mean, I could move this around, so it's the Commissioner of Corrections, blah, 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 for adopted by the Secretary of the Administration by on or before January 1, 2027. I can switch it around.
Why don't we do that? Okay.
And I don't know, no one on this committee is on joint justice oversight, but I might just ask
They could look at it too, but
VSEA to somebody
Wait.
to make sure that joint justice oversight is aware of this.
who serves in the Senate on joint?
Make them work on it.
Right.
Nara is, Wendy is, it's a
Oh, no.
judiciary institution.
No, I know, I
I
just
just
couldn't
couldn't
remember who was on it.
I think Ginny's on it too.
I think Ginny is on it, because Dick was on it, and I remember having to do stuff with Dick and Ginny. Okay, so if people are okay with, wanna, when you,
Can you summarize what
I'm
you
gonna
think we're
just
okay?
have 2 seconds, yeah.
she's gonna show us. And Sarah Clark did stop by yesterday to give her, said that she was okay.
So, the Commissioner of Corrections or designee shall meet with representatives of the VSEA to develop a proposal governing permissible and impermissible solicitation of parking lots at the Department of Corrections facilities for adoption by the Secretary of the Administration on or before January 1, 2027, and then the Commissioner of VGS shall coordinate the meetings and provide assistance as appropriate.
Struggling a little bit. Essentially, it says, develop a proposal, blah, 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 for adoption. Adoption means it's a finalness as opposed to consideration, which doesn't require the Secretary of Administration to accept it.
True,
For
but the,
adoption.
Consider.
the administration will be,
It's unclear in terms of whether the intent of that is to be adopted by January or to have a proposal developed by the Senate.
So it would be consideration for adoption.
yes.
The final.
How about,
She may have just shown them.
So for
But
consideration.
the
why?
hope is to resolve this.
Yeah, why do they have to consider adopting it before the first?
Oh, the date, I'm not, a different issue. I just want to make sure I understood the
What it
intent.
means.
How
To
about,
adopt it.
how about for consideration and adoption? Because she'll be involved, the administration in 2 parts is involved in this. Nothing is going to happen without the administration being on board, because you've got DOC and VGS managing, working with the SEA. So I wouldn't, if you wanted to take consideration and adoption, I would be fine with that as well. But I think that we have to really be encouraging them to come to resolution on this.
But
Is
if
that
they
okay?
don't, they don't find common ground. What whole?
Then it'll probably come back to the legislature and people will ask us to somehow resolve. So, David, would you be open to consideration and adoption?
Consideration for adoption.
Sophie, you're a lawyer.
But it's up to you guys.
And adoption means it's finalized.
Okay,
It's a
consideration for adoption. That strengthens it, I think, in the way.
I think it says everything you wanted to say without forcing them
Right.
to say, this is the answer and I shall accept, the Secretary of Administration shall accept.
Thank you. I think that's fine.
So do you want for consideration for adoption,
No,
opposed to for consideration and
for
Consideration for.
consideration for adoption?
I like that.
okay, if we're okay with that change, are we okay with the second instance of amendment? Okay, good. Thank you. Thank you all for your work on it. Now we go back to the first change to the body of the bill, which is the Commerce Committee made that change.
General and housing.
I mean, I'm so sorry.
Which draft we're working, 2.1? Of the bill.
Because now we're looking at as passed by the House.
You're looking at that passed by the House, and that is,
We were just looking
Wait.
at that.
Yeah.
we're just looking at the amendments
So
and Sophie, are you able to pull up as passed by the House? I have it here. Here it is, the House proposal amendment, and it just says House proposal amendment. And the change they have. Well, Sophie can,
Yeah, so the change was,
on page 3, I think.
it's on
Self-attestation.
this self-attestation piece. This committee had added in that the self-attestation needed to be on penalty of perjury. And, the House took that piece out. So the language that's currently in the version passed by the House is identical to the language that's in the Parental and Family Leave Act. So this is what they added to the Fair Employment Practices Act. They just undid the piece that this committee had added in around perjury.
That I think you and Randy have the biggest concerns about this. I think we self-attested so many things that I'm
Yeah.
fine.
So I am still concerned, but in the spirit of ninth hour conflict.
Thank you. We would appreciate it.
Now, talking about Interstate 22A.
I want to take a trip with you on 22A after session's over.
Really don't, it's very boring.
A dark night with rainfall and heavy traffic.
And make sure you have.
So, Randy, you okay?
Yes.
So,
Tell the enthusiasm.
I can see that we sadly often do things for non enthusiastic benefit, but people move things on. So Thomas, I'd entertain a motion.
Are all five of you comfortable being on the proposal amendment that we just discussed?
It could be stylistic, but I just think the reporter of the bill should be the one on the amendment. I don't think the whole committee should, because if one
that-
person isn't, then it looks weird.
Is there a stylistic thing with that? Let's go.
I've
No,
seen it that, when you have a whole committee, but the committee doesn't have possession of the bill, that then all the committee members will be listed.
Can you
On
reference
the
it strongly?
amendment.
I can't.
Okay,
Yeah.
no,
Yeah,
So it shouldn't go
okay. If we do it with Chittenden and then we just do the straw.
Are there 3 articles of them?
to the one on healthcare providers and one on the corrections.
Otherwise, we're concurring. We're concurring with 2 additional proposals.
So I'd move favorably with further proposal amendment S 230 as outlined in draft number
It'll be 2.1 for both of those instances.
2.1.
I'll send them those to you.
And I'd ask for raising of the hand. Nation.
oh, yeah.
Okay, great. You have a 5-0 straw poll. Thank you, Sophie. Thank you, everybody. And we are going to, thank you very much. Thomas, would you feel comfortable doing it today and making the pro temp happy, or would you like to
I'm
wait?
gonna touch base with it before the floor and see what he wants to do.
Are you comfortable doing?
Sure.
Okay, great. And I'll send this. That will be great. Terrific. Sophie, thank you. And more to follow on other things. And Cameron, would you be, oh my God, look at this line out there. Jeez, this is what will help with our renovation at some point. So people don't have to wait. Jessica and Devin, thank you very much. This was
Guards are trained to delay the line when it's raining outside.
Yeah, I was gonna say, this is what our renovation will improve here. Okay. Now we're gonna shift from labor to landlord tenant law. And we have just to refresh everybody, we had a good conversation with the court. On Monday, we have an amendment that reflects that. I think there's some challenges, but we have some suggestions for things to consider. And we have slimmed it down to really 4 key areas with some additions. So
Can I ask, are we trying to take a vote before?
no, I don't think we have
Okay,
time.
so
We have
that'd be
spent
better.
too much. I mean, we spent a good time on 230, but we have not spent probably enough time on this, although if people feel comfortable by 5 of 10 in 20 minutes. on this bill,
Well,
I'm
I
happy.
mean, like, I do think, I'm glad we moved some other things. I do think it's it's important that if anybody has a remaining issue, they're doing work outside of our committee time. Like,
I would agree.
this is the time of session where it's up to each individual senator if they want something to pass or not to pass, that they are working on language or they're ready to.
Here, I assume that people are doing that. I certainly to that effect.
Can I just
Yes,
try to find my feet here? So the last time we were talking, we had 5.1 dated May 7. Now we have 1.1 dated May 11.
our,
What it is?
our legislative council is going to share with us why. Council, welcome.
Good morning. For the record, Cameron Wood, Office of Legislative Counsel. I will share my screen, start walking through this draft language one. So, Senator Weeks, to your question directly. The draft that we all have been reviewing, draft 5.1, is the recommended proposal that came out of the Senate Judiciary Committee. And so you all have been making changes or looking at recommending changes to that proposal. So I needed to draft an amendment from this committee. So draft 1.1, what you have now is the recommendation of this committee to amend the proposal of the Judiciary Committee. And so you're going to have, I think there are, in this version, there are 7 instances of amendment to the report of the Judiciary Committee. And if you want to reference the report of the Judiciary Committee, you see that draft document because that's the version they voted on. Okay, so the first amendment here is striking.
And I just would point out, I believe council will share, we have some decision points.
Yes,
This is not an amendment that we have a few key decision points that have been raised for further discussion, but it does reflect our conversation with the court on Monday, the court administrator and the Superior Court judge,
Judge Neve.
I know, but what's judge, what's Tom's title? Anyway,
Security.
right. The head of the courts, along with the other head of the courts, the head of the judges. So we had a very productive conversation with them. And we, I think, have reflected that Terry and Cameron worked on this language. And so the court study reflects the court's desires and I think our desires all together. So Cameron, take it away.
Nearly everything in this amendment. The remaining pieces here are the pieces that you all have been discussing and have not come to a conclusion on. So the first instance of amendment here is striking out section 1 and inserting in lieu thereof a new section. What this is doing is it's striking out all of the sections related to the residential rental agreement that you all chose straw polls to remove. So removing the cap on rent increases, removing the language around the residential rental application, removing the language regarding security deposits, removing the section regarding retaliatory conduct, etc. So all of that has been removed. So what you have remaining is really the key pieces are going to be on page 2.
I'm sorry, go ahead. My apologies. Can you go through that list? Yeah.
It's pages 1 through 6.
But these are all removed, so they're not going to appear anymore. I just want to make sure I get it.
Yeah.
Right, please.
So it's removing what was in 5.1, and it is the rent increases, the cap on rent increase. It's been removed, yes, sir. The changes that were regarding the residential rental application, which prohibited charging fees and which is current law, they gave a definition of fees. And then the language about the charging costs for credit and background check, that's removed. The limit on security deposits to 2 months rent, that has been removed. The section regarding the retaliatory conduct, so that has been removed. And then that's it. So what we have remaining here are the few pieces that you had left, this committee had left to discuss.
So it's, I understand that they are roughly grouped under the Good Samaritan provisions, the bifurcation of the lease agreement, and the bifurcation of the lease, the no trespass, and the study of the court. And everything else, we just did not have the time to dig in deep enough at this end of session, and which I am sorry about, but we will have to leave something for another legislative session. God forbid.
So to get you to page 2, agreed, Madam Chair, the pieces here that would remain within the residential rental agreements chapter in section 1 are these provisions here, starting on page 2 and move to page 3. So you have in the termination for each of the rental agreement, you have the subdivision 3 and subdivision 4, which still remain. Subdivision 3 is about the cannot terminate the rental agreement due to the medical assistance for a drug overdose. We've added the word solely there on line 9, which was discussion on Monday. Then you have 4A and B regarding the cannot terminate due to instance of domestic abuse, sexual assault, or stalking for a protected tenant. That remains. No changes to 4A and 4B, but there is the corresponding language when you go down to page 4. This is in the section related to the bifurcation of the rental agreement. So this is where,
In cases of domestic violence.
yes, ma'am, this is where the landlord may bifurcate the rental agreement if the tenant submits the written request requesting bifurcation. The landlord shall bifurcate the rental agreement if that written request includes a copy of a court order that requires the perpetrator to vacate. And then there was discussion about this subsection B on page 4, where it's the protected tenant. If there's a bifurcation and an ejectment of one of the parties to the rental agreement, the remaining protected tenant, if the individual can't cover that rent for that period, they have to be provided a reasonable time to seek additional tenants or to find other housing. And the key change here is the addition of this subdivision 3 on page 4, which states that nothing will prohibit or nothing shall prohibit a landlord from collecting past due rent or recovering losses due to damages from the terminated tenant or the protected tenant. So that was language that was, you all discussed striking this subdivision entirely, the B.
But this is new language from, I think, the advocates at trying to thread the needle, which the landlord could still continue to collect rent, because otherwise the landlord's out 3 months of rent or 3 months of rent. But also allowing,
As I see this working out, would be the landlord would have to give the person that 90-day period. And if the individual tenant was not able to find, an additional tenant, or was not able to find additional income to be able to pay for the entire rent of the property,
the landlord
at
would
the end of that 30 days, the landlord could move forward with terminating the rental agreement at that point in time.
90 days.
Excuse me, 90 days, yes, ma'am. The landlord could move forward with terminating the rental agreement if the tenant had not come to an agreement about how to cover the back rent that had not been paid.
I thought that we were assuring that at the end of that 90 days, the landlord would be made whole.
So, I mean, I don't think you can put in statute that, an individual has to pay. I mean, you could, I guess you could articulate that, a tenant has to pay any back rent at the conclusion of the 90-day period. I think this subdivision 3 would allow a landlord to move forward with a termination and recovery of that money if it was still owed.
Where do you
I
see this? I mean, I guess I'm not clear on how they recover the money.
It says that nothing prohibits the landlord from collecting it and recovering it.
Right.
But it seems to be kind of counter purpose. I kind of understand the intent here, but I still don't understand from the perspective of the landlord how they make themselves whole and when they make themselves whole. And from whom.
So it's one thing for me, and I appreciate the need to, when some of these things happen very fast and they're very unpleasant and they're traumatizing for family. I understand giving a family 90 days to resolve that, but then I had thought I'd understood that gives them 90 days to figure it out, but that after the 90 days, the if the landlord had given the tenant 90 days to resolve it, hopefully it would be resolved sooner than that. That the landlord would be made whole, but the landlord was not gonna be out 3 months of rent. Appreciating that there's a trauma that's being navigated. I get that, but the landlord also would be made whole by if as part of that 90-day figuring it out, they gotta figure out how to pay the landlord for the time that they haven't been paying the landlord.
So I don't think there's any language that you need to accomplish that based on the underlying B1 and B2. I mean, so B1 says that the landlord has to provide the reasonable opportunity to locate additional tenants and otherwise find new housing. It doesn't really speak to what the landlord's rights are in relation to any rent that's not paid. So I would argue, even if you just have B1 and B2, if there is 3 months of back rent that hasn't been paid at the conclusion of that 90-day period, the landlord can move forward with terminating the rental agreement for non-payment of rent. And then how do you recover your losses? You recover them the same way a landlord recovers losses at any point that a landlord isn't paid for rent. You ask for it as part of the ejectment action.
So this is just, as you see it, an extension of the time without being ejected. If they can't figure out how to pay the rent.
Right. It is a period where
Of transition that the landlord may or may not be financially supporting. I mean, they may get compensated for it or they may not. But it is not dissimilar to a time frame for non-payment of rent. Is that what you?
I don't know what you mean by that, Madam Chair.
So just remind us, we've got lots of experts in the room, to remind us to how many, I mean, in addition to yourself, how many months of no rent after which a landlord can begin eviction procedures.
Be 1 month of rent. If the landlord wanted to move forward for an eviction for non-payment of rent. The section simply says, sorry, I was trying to pull it up while I was talking, so. So this is in sub A. The landlord may terminate the tenancy for non-payment of rent by providing notice, which shall be 14 days. So if you don't pay rent in the first month, the landlord can terminate the tenancy based on that.
So this is possibly exposing a landlord for 2 additional months of no rent. Possibly. Is that what I understand correctly in this?
It is requiring that the landlord provide that protected tenant with a 90-day window to seek additional tenants or to seek additional housing. That's what the language says. And I would argue that the language would prohibit a landlord from moving forward with a termination due to, non-payment of rent within that 90-day period. So the landlord could be exposed to 90 days of non-payment of rent. But again, there's nothing in the language that would prohibit a landlord from then moving forward with an ejectment and seeking past due rent from the remaining tenant as part of the ejectment action. So this section 3 is just adding in language to specify and clarify to make that explicit.
Okay, so this is question number 1.
Yes.
This is our first question.
Yes.
Let's go to our second question because we just have a few minutes.
Yep. So that's related to the bifurcation. So you all were discussing, again, if you go up to the top, you have the Good Samaritan piece in 3, you have the bifurcation at 4. There was some discussion about, disabilities and whether or not that should be included. That's not here in language. Let's see. So then when you move to the next instance of amendment is the 3rd instance of amendment on page 4. Now we're switching and we're going to the trespass orders.
So we're now in the no trespass section.
Okay. And I'm going to pull up the no trespass section in draft 5.1.
Would it be argued that this is squarely in the domain of the judiciary? The work they did is on. Did they do the work on the trespass?
They did, and this is making an amendment to their sections. You're correct.
It is a criminal trespass section, so it is in the statute related to crimes. So just real quick, I pulled up 5.1 to reorient us to what we're talking about here. This is where the landlord may cause to be served an order against trespass to a tenant's invitees or licensees, so the tenant's guests. If any of these 4 conditions are met, the tenant consents, the guest has violated the terms of the dwelling unit's lease agreement, the guest has violated state or federal law while on the premises, or the guest has previously been ejected from the dwelling unit pursuant to a termination of the rental agreement under 9 BSA 4467B. And the discussion from Senator Ron Hinsdale was to limit that sub B when you're going to issue the no trespass for the violation of the lease agreement. Then there needs to be a pattern of violating the lease agreement, so it couldn't be one instance.
Unless it was a violent, or dangerous,
So
that is an action that's on your in your thing, B1 and 2, that they could still be ejected.
I'm gonna get there in just a second. That's about the ejectment, when somebody's been ejected, yes, ma'am. But just this piece is the sub B, where it's just if you're issuing a no trespass because the guest is violating the terms of the lease agreement. The language as it came out of the Judiciary Committee was the invitee or licensee subject to the order has violated the terms of the lease agreement. So it would only require one violation. And the request was to change it to describe a pattern of violating.
But a violation of the lease agreement is a criminal activity,
Doesn't have to be.
or
That's, you're thinking about the next instance of amendment when we get into this B2, when you're talking about B1 versus B2. Not there yet. I'm just talking about,
okay, but the problem is you don't necessarily need a pattern of bad behavior to have a bad behavior that's egregious enough to want to reject them. So
correct,
the judiciary's having discussed this, I'm yeah.
correct.
Although Thomas, just you should know, we sent this to Nader yesterday, so he's looking at these all these changes. So that
Just a process question. So we're reacting to the Judiciary Committee.
Yes.
Okay, so the language which is not in the Judiciary's draft, but is in 5.1. So that's the one.
no, 5.1 is the judiciary draft.
So
You're amending their video report.
So let me be very specific. Positive rent reporting program. It's not in this draft.
Sorry, what's not in?
Positive rent reporting program. Okay.
Yeah.
Not in. Okay. And
So we decided, because of our time frame, we had to really just limit it to the things that they a few things from our sections and some of theirs. Just to go, Thomas, to what they did. They actually took, I feel very good about the court study work because they actually took no testimony from the court. So Nader was grateful for us having done it. So we will continue this on Tuesday. Thank you, everybody. We will continue this at 9 o'clock on Tuesday. If
Not
that's all
tomorrow.
right. Not, oh, tomorrow. Oh, yes. Oh, there's tomorrow. Again.